We're talking about the recent Supreme Court decision upholding the reduced size of Toronto City Council as a constitutional move by Premier Ford. So, Jacob, this went all the way to the Court of Appeal and ultimately to the Supreme Court. So can you elaborate on what these other levels of court held about whether freedom of expression was engaged by reducing the size of City Council in Toronto?
So both the majorities of the Court of Appeal and the Supreme Court, so in the Court of Appeal is a 3-2 split, and in the Supreme Court it was a 5-4 split. So 5 judges ruled that Ontario's legislation imposed no limits on freedom of expression. And what they found here in a big portion of this case came down to the timing of the provincial government's decision. And what the majority found specifically in the Supreme Court was that there was adequate time after the legislation was announced and the new structure was created, in fact, 69 days for candidates to reorientate their message and to convey their message to voters. And these 69 days is, in fact, longer than a lot of provincial and federal elections have been. And the court found that this amount of time did not radically frustrate voters or candidates' freedom of expression and did not effectively preclude their ability to have meaningful expression. The court gave the example that had it been only a 2-day election period, for example, that could have been enough to frustrate and preclude meaningful expression. But given the amount of time, that wasn't the case. The court also found that by changing the structure, they may have been making some candidates' expression less effective, but that's not one of the guarantees under the charter. And finally, as we talked about before, the court confirmed that Section 3, which guarantees the right to vote, does not apply to municipal elections and cannot be subsumed by Section 2B under freedom of expression.
Yeah, it certainly felt like the city was trying to sort of stretch or twist what some of our charter guarantees are in order to fit their case or what outcome they wanted into those rights. And Joanna, I know that you had a lot of concerns with that type of argument. What can you say about your concerns about what the lower case held and also on how quickly this case moved?
Yeah, so I think Jacob laid it out clearly that essentially the judge, Bellababa, imported these Section 3 voting rights into the freedom of expression charter right in order to circumvent the decision. And effectively, there's a clear legislative decision in Section 3, right, to protect provincial and federal, but not municipal decisions. And whether we like that or not, we've got to either put it up for constitutional amendment or live with it. And then once he had done that, he gets into this very granular question about what award should be, what award structure should be in order to comply with the Constitution. And it seems to essentially come down to timing. He talks a lot about notice and this happening mid-election, but it seems like it would have been even worse if the government had done this after the election, for example. In terms of timing, of course, obviously the Court of Appeal issued its stay very quickly. Probably because of the timing of the election. And from there, the question was somewhat moot because obviously we weren't going to void the Toronto City election. And then it proceeded along longer lines because there obviously are perennial constitutional issues, which we'll continue discussing arising from the decision.
So the timing has been a big part of what this lower court decision was. Mark, do you think if this had happened outside of the campaign period, for example, if the Premier made the amendments a few years before an election, do you think we would have had any of this go to court?
Christine, I think that's a very interesting question, but I really do think the factual context here, the fact that it happened during the election was what really gave the challenge some teeth. That's only because we know that as Joanna said earlier, municipalities are just creatures of the province. The province basically has entire control over the makeup and structure of municipalities and their councils. And it was the specific fact that the province chose to exercise that power during the election that kind of gave rise to the arguments Jacob was talking about, where the candidates were arguing that their right to make representations and to campaign in the city were violated. So without that context, without that election happening, the issue kind of loses some of the power. Now, I think it still would have been a controversial move, to say the least. I think if there may have been a constitutional challenge, even if it happened before the election. But again, the timing here is what was really at issue, I think, in the lower court, and certainly in the dissent at the Supreme Court of Canada.